the Child Care and Protection Act. Section 42, restriction on presence of child in court. Subsection 1. No child other than an infant in arms shall be permitted to be present in court during the trial of any other person charged with any offense or during any proceedings preliminary thereto, except during such time as the child's presence is required as a witness or otherwise for the purpose of justice, or in such other circumstances as the court may determine. So, the child must keep out of the court until the court call them. And once they make their contribution, they go back out of the court. Subsection 2. The court shall order the removal of any child who is present in court in contravention of this section. So if the judge see a child in the court and they should not be there, then the judge order that they be removed from the court. Section 43, power to clear court when child in court. Subsection 1, where in any proceedings in relation to an offense against or any conduct contrary to decency or morality, it appears to the court that a child who is called as a witness is a child, the court may direct that all or any persons not being members or officers of the court, parties to the case, their attorneys at law, or persons otherwise directly concerned in the case, be excluded from the court during the taking of the evidence of that witness. So, the judge can clear the court of all persons not essential to the case. Subsection 2. The powers conferred on a court by this section shall be in addition and without prejudice to any other powers of the court to hear the proceedings in camera. Section 44. Power to prohibit publication of certain matters. Subsection 1. In relation to any proceedings in any court which arises out of any offense against or any conduct contrary to decency or morality, the court may direct that a. No report of the proceedings shall reveal the name, address, school, or include any particulars calculated to lead to the identification of any child concerned in the proceedings, either or being the person against or in respect of whom the proceedings are taken, or as being a witness therein. So, no information that can identify the child be published. The court can make that order. B. No picture of any child so concerned in the proceedings as aforesaid shall be published, except insofar, if at all, as may be permitted by the direction of the court. Subsection 2. Any person who publishes any matter in contravention of any directions given under subsection 1 commits an offense and is liable upon summary conviction before a resident magistrate to a fine not exceeding $1 million or in default of payment to imprisonment for a term not exceeding 12 months. So, if you publish identifying information against what the court said, or if you take picture and publish them without the court's approval, then you pay $1 million fine and or imprisonment up to 12 months. Section 45, restriction on newspaper reports of proceedings in juvenile courts. Subsection 1, no report of any proceedings in a children's court shall reveal the name, address, or school, or include any particulars calculated to lead to the identification of a child concerned in those proceedings, either as being the person against or in respect of whom proceedings are taken, or as being a witness therein. Nor shall any picture be published as being or including a picture of any child so concerned in any such proceedings, provided that the court may, in any case, if satisfied that it is in the interest of justice to do so, by order dispense with the provisions of this section to the extent specified in the order. Subsection 2, any person who publishes any matter in contravention of this section commits an offense against this act.